All right, so I want us also to be able to comment on the Supreme Court, but before then, we had another debate, that's the secession debate, and you heard from Kenyans. I mean, one, Kenyans that were sampled from Coast saying that yes, let's secede, and the ones from Nyeri, which has been singled out, say that no, this is not really the answer to the issues that we are dealing with as a country. And Kefa mentioned something else. Shouldn't this be the last resort? Really, have we gotten there? Should we talk about better distribution of resources and funds to the counties, holding the governors accountable, and improving the life of the Kenyans straight from the grassroots level, instead of really thinking about seceding, because that's really it's not even the silver bullet to any situation. It's like a grenade or a rocket-propelled grenade to any issue. I mean, is that really the way to go?
Well, Betty, Kenya is composed of 44 different tribal groupings. We are 54 years since our independence. We have only seen 2 ethnic communities taking the reign of power interchangeably. Under only 3 families. 54 years, 2 communities, 3 families. That is a harsh indictment on democracy. Not because people love them so much, but because elections are always stolen, so that a few can benefit from this. And why people then steal elections is because, firstly, the communities would therefore think that if one of them is powerful, then they're equally powerful over other people. Number 2, they look at it as a leverage towards economic progress, such that, and this is a matter of fact, just a while back, a head count was carried out by the Public Service Commission that showed that 65% of jobs within the public service are held by 2 communities. 2 communities out of 44 communities have 65% of jobs within the public service. That is utterly unacceptable. If every Kenyan is paying taxes to go towards servicing the government together with its projects, then every public sector must have the face of Kenya. And that is one of the tenets of the Constitution. Now, you talked about strengthening devolution. That actually ought to have been the panacea towards addressing this issue of exclusivity. But what are we seeing? Jubilee government, of course it is common knowledge that most of the functions were devolved to the counties. And once a function is devolved, money must therefore follow. But for instance, you look at the health docket that was devolved to the county government. You tend to see that out of 80% of resources that is meant to go towards health, that should therefore go deep to the counties, because that is where the service is. You only see the national government releasing just 20%. Now, the essence of devolution was to have the national government retain some little money for supervisory responsibility. And that also includes policy making at the national level. But what have we seen? The national government therefore reversed the roles, taking 20% to the counties and retaining 80% at the national level.
All right.
So you ask yourself, does devolution therefore give services to the Kenyan people? Number 2, you look at the roads, for instance, where road classes A, B, and C ought to be undertaken by the national government, such that D, going deep downwards, would then be under the purview and control of the county government. But what we therefore see is that even certain D-class roads that ought to be done by the county government are then upgraded to become C roads, so that the national government can reel its ugly head on the funds of these particular roads.
All right.
So it has been a disorganized way of perpetuating the same exclusivity, siphoning powers from the people, bringing it back to the national government, so that when you have politicians who are greedy, who would then be kneeling down every morning at the doorstep of the deputy president, the president, ministers, and directors of various ministries, so that they can have greater benefits on behalf of their people to the detriment of devolution.
All right. Interesting. So we will continue to really delve deeper into this secession debate. We cannot even finish it here because of the extreme divergent views on it. But also because we're running out of time, I want us to touch also on the Supreme Court. As you can see, quite a number of activities here on there, and that's because any moment now we'll be having the chamber now sit down and have the pre-trial conference. Kafa, being a legal mind, what are we expecting as the guidelines for this particular hearing?
But if you may allow me just to comment something shortly
Very
on the session
briefly, because we have about 7 minutes to
about
go.
the question of cessation that we were talking about. You see, we have identified the problem, but what we're lacking now is the measure. You see, the Catalonian move that I would wish NASA will adopt is that you identify critical issues that are facing the Wananchis, the Kenyans. Identify those issues that have not been resolved. Then tell Kenyans, we have tried this plan, we have tried this plan, this have failed, and this have failed. And now this warranty cessation now as the last resort where we are moving. Because as we sit here, Betty, even Agenda 4 of the Kriegler's report has not been, has not been implemented. That is the major ground that will even settle this before we get to secession. If, laws are made for people, not people made for laws. If people feel that the issue of certain communities being in positions of power for long has been the problem, why not even amend our constitution for a referendum so that we have rotational, presidency for all the communities?
Right.
This problem will end. I think secession is right, but let us treat it as the last resort. If all politicians can come and agree that we have a problem, number one, and this problem must be fixed, and we are not going to postpone it, let's sit down and fix it this time round, I think we can do it.
All right.
Back to the Supreme
Coming to the Supreme Court, very briefly also, we are running out of time.
The Supreme Court today is what we call the pre-trial conference. A pre-trial conference, simply you set down the ground rules on how you will be operating, who are the counsels for the petitioners, who will be the lead counsel, the party they will be dealing with, and then again the preliminary issues to be discussed on what formula. Another issue that's also going to be raised, very critical, is the issue of consolidation of matters, because if you see the petition by Njonjo Mue, Alif, and the petition by Aaron Mwao, they're almost similar in nature. They almost raise same issues. So there's a possibility that the parties can also agree to consolidate these matters alongside. Another question is the mode of hearing. Which petition will be heard first? Is this for the petitioners, or is it the one for by Kioko Kilikumi challenging, accusing Raila of being a NASA and the colleagues for committing an electoral
democratic governance,
something like that. So they'll also agree on the mode of operation on that. Another question which is very critical they're going to deal with today is the question of amicus curiae and the interested parties. Remember, Kuro Court has applied again to be included as interested party in that, and the Attorney General, I know, will come as an amicus curiae. Then from today, they will agree also on the timing, how much which party will be given to submit, and the rejoinders, and for how long will they, require also to deal with the issue of submission.
All right.
Yeah.
All right. Thank you very much. Coming to you, Honorable Jared Okello, what are your expectations for this? The Jubilee lawyers, President Uhuru Kenyatta's lawyers said that the NASA is using the petitioners as their surrogates and mouthpieces. But very briefly, a comment on that and your expectation on this particular petition.
Firstly, NASA is disinterested in what is going on at the Supreme Court, because as far as we are concerned, there wasn't any election. That has to be underscored. Then secondly, you can see the expectation of the Kenyan people as regards the Supreme Court moving forward now has since dissipated. Why? The Supreme Court of Kenya made history on the 1st of September when they nullified a presidential election, having been the third in the entire world, the very first of its nature in Africa. But again, few days later, on the 25th of October, they unmade the same history that they had made. To date, we haven't been told exactly where these judges were, leaving the Supreme Court Chief Justice, the Chief Justice and the President of the Supreme Court, to sit alone on the bench, single person. Out of the 7 judges, he was just a single person. Yet, the case that was before them was very pivotal as to the occurrence or lack of it of the elections of the 26th. Right. So these are very critical issues. Now I can see they have paraded 6 chairs there. Are they therefore ready now to come to work, even without telling Kenyans where exactly they were on the 25th of October? Now, it is not a charity. They are not exercising philanthropy when they come to work in court. They have a duty to do on behalf of the Kenyan people, to appear and litigate any matter that appears before them. Article 140 of the Kenyan Constitution gives every Kenyan a leverage, a latitude to file any presidential petition before the court. That was one of those. And the Constitution has given them powers, not just to litigate on issues of presidential elections. I mean, they offer advisory opinions. They can sit as an appellate court from cases emanating from the Court of Appeal. But people then become, do not come to work. And to date, no one has come out to explain. I only hope that the Judicial Service Commission, being the employer, will be able to analyze, investigate, and provide a cogent explanation as to where these judges were. Because then we know that by Monday, they should be providing a solution towards this petition. What if they don't show up on Monday? Does that therefore create a constitutional crisis? What if only the Chief Justice would show up on Monday and say, my colleagues, firstly, one has had the driver being shot. The 2 I cannot find on their phones. 1 has been stuck somewhere and cannot access a flight to Nairobi. I mean, that kind of expectation and the history that they made on behalf of the entire world is now gone. So I want to believe that Kenyans, moving forward, lack optimism from what will come out of the Supreme Court. But I still have to reiterate that we as NASA are totally and utterly disinterested in the proceedings before the Supreme Court.
All right. Thank you very much, Honorable Jared Okello. He's a Nando Member of Parliament. And I've also been speaking to Kefa Ojijo, who is a lawyer. And I hope we'll get to hear the reasons, really, because that seems to have just fizzled out after the October 25th date. Nobody's really talking about that. So hopefully we'll get to understand, why, they were not there to sit and, of course, to do their duties, that Kenya accorded to them. All right, so we have to